In the last session, we learnt about the written statement, set off and counterclaim. Okay. In this video, we are discussing about the pleadings generally. Pleadings means either the plaint or the written statement. Okay. The plaint of the plaintiff is the pleading of the plaintiff. The written statement of the defendant is the pleading of the defendant. Okay, friends. And this order 6 deals with what contents the pleading shall contain and what contents the pleading shall not contain. Okay, friends. Rule 1 of order 6 says that pleading shall mean the plaint or the written statement. Okay. Rule 2 says that the pleading, either the plaint or the written statement, shall contain only the material facts relating to your case, not the evidence to prove those facts. Okay. Adducing evidence will come at the later stage at the time of trial of the suit, not in the pleadings. Therefore, it is evidence is prohibited to be included in the pleadings of the plaintiff or the defendant. Okay, friends. Rule 3 says that the forms of plaint or the written statement, as mentioned in Appendix A of Civil Procedure Code, as practicable, shall be used for the purpose of pleadings. Okay, friends. Rule 4 says that particulars of misrepresentation, fraud, breach of trust, undue influence, and the other defenses which are mentioned in the forms of Appendix A shall be alleged in your pleadings. Okay. Rule 6, if any condition precedent is there and question relating to performance of a contract or occurrence of an incident, etc., is to be alleged, you should allege. Okay, you should mention in your, specify in your pleading. Okay, friends. Rule 7 says that you shall not take a new ground or the facts which are inconsistent with the facts in the previous proceedings unless permitted by the court by way of an amendment. Okay, friends. Okay. Rule 8 says that if the plaintiff, a contract is alleged, the facts of a contract are alleged and the other party denied those allegations, then the denial must be construed as in relation to the facts only, not with regard to the denial with regard to the legality. Okay, friends. Now we will come to rule 9. Effect of document. If you rely on a document, you would like to mention it in your pleading. You shall not reproduce the contents of whole contents of the document or part of the contents of your document in your pleading. You shall just mention the effect of the document, like it is a gift deed, or you derive the title by way of gift deed or sale deed or a family partition settlement deed, etc., etc. Okay, friends. If you rule 10 of order 6 says that if you want to plead malice, fraudulent intention, knowledge or other condition of mind of a person, you shall plead the said fact relating to these things of a human nature, not the circumstances inferring them. If it is a fact, mention it. No, if it is a circumstance which leads to inference of this fact, shall not be pleaded. Okay, only the fact of this malice, fraudulent intention can be pleaded. Okay, rule 11 of order 6 says that you shall specify in your pleading regarding the notice of a fact to the other party. Okay, rule 12 of order 6 says that if you want to take if you want to specify about implied contract or implied relationship of a person, you should specify it, but you shall not go into detail of these facts. Okay. Rule 13 of order 6 says that no presumption of law shall be specified or pleaded in your pleading, because presumption of law is a matter of law, not a matter of fact. Okay. And for example, if you file a document more than 30 years old and you can't plead in your pleading that presumption is in my favor as per the provisions of the Indian Evidence Act. Okay. And rule 14 says that the pleading shall be signed by party and his advocate. Okay. Rule 15 of order 6 says that verification shall be made by the party at the foot of his pleading. Okay. And he shall also mention as to what numbered paragraphs he is going to verify on his own knowledge, and what paragraphs he is going to verify on the information received by him or on his belief. Okay, this is rule 15. Okay, like this, the contents in paragraph 15 to 16 are read over and explained to me, and they are true and correct to the best of my knowledge, belief or information. Okay, rule 16, if the pleadings, if any of the pleadings are scandalous, frivolous, etc., etc., then the court may strike out any pleadings of the parties. Okay, rule 17, friends, says that the court may order for amendment of the pleadings of either party for proper adjudication of the suit, and such amendment shall be made only if the real controversy in the proceedings is to be decided properly. Okay, the provision to Article 17 says that the applications for amendment shall not be filed after the trial has commenced, unless the court finds that despite due diligence exercised by the party, he could not do so before the commencement of the trial. Then the court can allow for amendment of his pleadings. Okay, friends. Rule 18 of Order 6 says that after amendment, the amendment shall be carried out within the times fixed by the court or within 14 days from the date of such amendment, unless the time is extended by the court. Okay, friends. Thank you for now.